It's a privilege and pleasure to be here in this university with distinguished participants and audience. So I was going to have some slides, but if not possible, it's not a great matter. But if this stuff is here, they can help us. Anyway, I'll start. So I'm going to talk about UNRWA, which is a UN agency for Palestinian refugees. I think I can be a little bit descriptive in the beginning, since most of the audience are students, so I can explain what is UNRWA first, and then I'll skip to attacks by Israel on UNRWA, and then I'll be talking about the reasons for Israel and its Western allies to attack UNRWA, and then I'll be talking about the latest attacks on UNRWA by Israeli Knesset. There is a response by the United Nations General Assembly to this latest attack, which is an advisory opinion request by the International Court of Justice. And then I'll be talking about a little bit about the technical features of this case before the ICJ. All right, so UNRWA is United Nations Relief and Work Agency for Palestine refugees. And this is a UN agency established by the UN General Assembly in 1949. And its mandate is to provide humanitarian assistance and essential services to Palestinian refugees who were first forcibly displaced as a result of ethnic cleansing campaign during the Nakba of 1948 by Zionist paramilitary groups. So during that period, nearly 900,000 of Palestinians have been forcibly displaced from their homes. And these constitute 2/3 of all Palestinians in the land at that time. Palestinian refugee problem is now one of the most enduring refugee crises in the world. UNRWA has been the primary lifeline for Palestinian refugees since its beginning. And it provides critical education, healthcare, social services, and emergency relief for Palestinian refugees. And it operates in 5 main areas. These are Syria, Lebanon, Jordan, Gaza, and West Bank. So today, there are almost 6 million Palestinian refugees registered with UNRWA. Those refugees rely on UNRWA's basic services. So despite this crucial role, UNRWA has been facing serious attacks, political attacks and financial attacks by Israel and its Western allies. So a clear example of this happened in February 2024, last year in these times, when several Western governments quickly suspended funding to UNRWA after Israel accused a handful of UNRWA staff of being involved in the Al-Aqsa flood operations carried out by Hamas and other resistance groups. So what is striking is how quickly these governments accepted Israeli claims without any question, with no question, no independent investigation, no due process. So they simply endorsed Israeli narrative and withdrew life-saving aid for millions of Palestinians in times of genocide. Yeah, this timing couldn't have been worse. This decision of suspension of funding came just after the ICJ ruled in South Africa versus Israel case and indicated some provisional measures, which included that Israel has to ensure the delivery of humanitarian aid to Gaza Strip to prevent genocidal conditions in Gaza. And these Western governments did the exact opposite by cutting funding to UNRWA. So UNRWA is the main agency, main humanitarian agency. All other NGOs rely on UNRWA's framework in Gaza. So there is no alternative to UNRWA in Gaza. So suspending funding to UNRWA means, I think it is equal to creating genocidal conditions, because without the UNRWA services, the survival of that group, which is a protected group, is not really possible. So those Western governments knowingly suspended funding to UNRWA when Palestinians needed the agency the most. I think this was also a violation of the Genocide Convention, because Genocide Convention is not only about not committing a genocide. It also imposes obligations to prevent genocide as well. So, and this obligation to prevent genocide, I think, started when ICJ indicated provisional measure. And this was a point which was argued in Turkey's declaration of intervention to the South Africa case. Turkey said that this obligation to prevent genocide started at least from 26th of January, when the ICJ ruled provisional measures. Okay, so I can talk about the reasons why Israel targets UNRWA a lot. So the main aim is to eliminate Palestinian refugee problem. So the refugee status is inherited by new generations, and UNRWA institutionalized this, institutionalizes Palestinian refugiehood. So as UNRWA continues to register Palestinian refugees, the number of people who claim the right to return to their original homes only increases. And consequently, Israel is never relieved from the burden of this refugee issue, and it will always come to the table when there is a talk. So the right of return represents the greatest threat, I think, to this Zionist character of the Israeli state. And the thing is, it is not only limited to the occupied Palestinian territories. It also includes what is now called Israel proper. So people have a right to return to their original homes, regardless of whether it is in OPT or Israel today. So even after 75 years of settler colonialism, the demographic balance in the Mandate Palestine remains nearly equal. If you look at the numbers, statistics, there are 3 million Palestinians in West Bank, 2 million Palestinians in Gaza, 2 million Arab Israeli citizens in Israel, and the total population of Israel is 9 million, and 7 million Jewish people is there. So it's like 7 million. So the project is still going on, and the right of return can significantly change this. So that's why it's a great threat, I think. So Israel seeks to erase the Palestinian refugee issue by dismantling UNRWA. But we must say that the right of return exists under international law, regardless of the existence of UNRWA. It's going to remain, whether UNRWA terminates or not. But Israel is trying to damage these claims by dismantling UNRWA. Okay, so the most recent, I have to be quick, I think. The most recent attacks on UNRWA came last year, 28th of October, by a law passed by Israeli National Assembly. So they passed 2 laws in relation to the operations and activities of UNRWA. So the first law said UNRWA activity within Israel is going to be banned. So the agency is not going to be able to maintain its operations within Israeli territories, including East Jerusalem. The second law says that it revokes Israel's 1967 commitment to facilitate UNRWA's activities in Gaza and West Bank. So there was an agreement between UNRWA and Israel in 1967 when the occupation began. So Israel said that they are going to facilitate the UNRWA's operations in these occupied lands. And then by this law, Israel revoked this commitment. And That law also bans any Israeli communication with UNRWA. All Israeli citizens and diplomats are banned to interact with UNRWA by that law. So another important thing that this law strips UNRWA personnel of their legal immunities and privileges they hold as United Nations staff. So United Nations staff has immunities and privileges. So this also includes UN premises, UN buildings. So Israel also aims to attack the immunity of UN premises in Jerusalem. And there are news that Israel is planning to turn those UNRWA buildings into settlements. Okay, so now that we can come to the point, in response to these UNRWA ban laws, the UN General Assembly turned to the International Court of Justice, and it asked for an advisory opinion from the court a few months ago. And for international lawyers, I think this move feels like the history repeating itself. So you will surely remember the story of Count Folke Bernadotte. Yeah? So in 1948, he was a UN mediator for Palestine, and he created a report in 1948. He emphasized that for peace, he said, Palestinian return is inevitable. And after this report, he was assassinated in Qudus by Zionist paramilitary groups. I guess so, yeah. So today, similarly, Israel's focus has shifted to UNRWA. And the UN General Assembly sought, again, legal clarification from the ICJ. At that time, the UN General Assembly did exactly the same thing. They went to the ICJ asking for an advisory opinion, and the result was the reparation case, which is a famous case for the legal personality of the United Nations. So decades later, right now, the UN is once again looking to ICJ to confront Israeli attacks on its own personnel, Palestinian rights, and international law in general. You know, in each advisory opinions requested by the ICJ, there is a question. And this is the question. This is the question that the UN General Assembly asked to the ICJ. I can read it quickly. International Court of Justice. So what are the obligations of Israel as an occupying power and as a member of the United Nations in relation to the presence and activities of the United Nations, which is UNRWA, including its agencies and bodies, other international organizations and third states, in and in relation to the occupied Palestinian territory, including to ensure and facilitate the unhindered provision of urgently needed supplies essential to the Palestinian survival. Anyway, it goes on. So we are going to see soon that states making their written submissions in the case, written statements, and the court fixed a deadline for this, which is 28th of February. I think Turkey will also make a submission. And there are a few points that I want to address in a very limited time, I guess. It's going to be enough, hopefully. So first, General Assembly asked the court to render an advisory opinion on a priority basis with the utmost urgency. And Article 103 of the rules of the court provides a ground for this, which is here. I think you're not going to be able to see, but I can give the background. So it says the court may take all necessary steps to accelerate the procedure, and it shall convene as early as possible for the purpose of proceeding to a hearing and deliberation on the request. So while the court seems to take an action and fix the time limit for 28th February, the problem is that UNRWA ban by Israel already started last month in January. So the court could have set another time limit for this before the ban enters into force. So this information was available to the court because Israeli law clearly says that this law is gonna take effect in 3 months. So the end of 3 months was the end of January 2025. This unfortunately effectively left UNRWA without legal protection, necessary legal protection. So the second matter that I want to address is an interesting point. Although this is an advisory opinion, it may differ from traditional advisory opinion processes. This process is more like a contentious proceedings. On the one part, there is United Nations. On the other side, there is Israel. So, and then this indeed may operate as a dispute settlement mechanism between United Nations and a member state to the United Nations. So, and then this comes from a specific agreement, which is the Convention on the Privileges and Immunities of the United Nations, which was adopted in 1946. Section 30 of that agreement says, all differences arising out of the interpretation or application of the present convention shall be referred to ICJ. And it says, if a difference arises between the UN and another member, a request shall be made for an advisory opinion on any legal question involved in accordance with Article 96 of the Charter, and the opinion given by the court shall be accepted as decisive by the parties. So we can say that there is certainly a difference between the UN and Israel in relation to the immunities of the UN premises and the UN personnel. So therefore, this mechanism is quite proper for this dispute. And another interesting point is whether this decision is binding or not. Although it's an advisory opinion, the last sentence of the article says that this is going to be accepted as decisive. So what does it mean? What does it imply? So is it going to be binding, or does it just say it is a final solution, or are these things any different? But there is also this thing. I mean, how can a decision be advisory at the same time and binding on the other hand? But it seems that there is some room for interpretation to say that this article may create binding obligations. And some authors indeed made this argument, and they said this is going to be binding on the parties. So the final point that I want to address is, again, in the case, whether ICJ can issue provisional measures in this advisory opinion, because this is very similar to a contentious case. And there is an article in ICJ statute, Article 68, and it says, in the exercise of its advisory opinion functions, the court shall further be guided by the provisions of the present statute, which apply in contentious cases, to the extent to which it recognizes them to be applicable. So sometimes it means that the procedures which are related to contentious cases might be applicable to advisory opinions as well. So this is another point. But the thing is, the General Assembly did not ask for these provisional measures. But some authors again argue that the court itself has the authority to indicate provisional measures, even in the absence of request. But there is no historical example of this. And considering the lack of request by the General Assembly, it seems that the court will not take a proactive approach. And also we know that this court is quite a conservative judicial body, so it might be a little bit unrealistic to expect. But at least the General Assembly could have asked for could have been more assertive by asking provisional measures, because there is a little bit example in the past which shows that the General Assembly could at least make some references to provisional measures anyway. So at the end of the day, we will see whether this decision will help to the survival of UNRWA. The court decisions cannot enforce themselves. Indeed, in these days, we know that the world started talking about the exact opposite things, like ethnic cleansing of Palestinians from Gaza to Egypt or Jordan. And we cannot simply wait for Israel to comply with international law. That would be foolish. We know that they have never complied with the previous decisions of the ICJ. Rather, instead of waiting for these courts to do something, states have to apply international law. They need to take action based on these decisions, and they should impose coercive measures. In this regard, I think the recent initiative by some Latin American states are quite important, which is called the Hague Group. Such alliances to isolate Israel must expand as soon as possible. And the thing is, most of the Muslim majority states are not there, so they should join to such alliances to increase pressure on Israel. Thank you so much. I'm sorry if I exceeded the time limit.